Welcome everyone, and thank you for joining us for today's webinar, Three Tails on One Rabbit, Preserving Justice Through Traditional, International, and Federal Systems, the United Nations Declaration on the Rights of Indigenous People. My name is Rebecca Horse-Chief. I'm Osage from Pawhuska, Oklahoma, and I'm the Program Coordinator for the National American Indian Court Judges Association. I'll be moderating today along with Ansley Sherman.
Hi everyone, my name is Ansley. I'm Muskogee Creek from Oklahoma as well, and I am program attorney for NYJA. We want this to be an interactive experience, so please feel free to ask questions throughout and make use of the chat feature and answer any polls as they pop up throughout the webinar.
Thank you for your time today, Judge Gregory Bigler and Professor Kristen Carpenter. Ansley, let's start with your bios, and we'll hand it over to our presenters thereafter.
All right, Judge Gregory Bigler. Judge Bigler graduated from Harvard Law School in 1985 and received an LLM in 1988 from Wisconsin Law School, serving as the Hastie Fellow in 1985 to 86. Since that time, he has worked almost exclusively with Indian tribes, serving as attorney or judge for numerous tribes in Oklahoma and elsewhere. He was the first district court judge for the Prairie Band of Potawatomi Court in 1992. He currently serves as a district court judge for the Muskogee Creek Nation, chief judge of the Court of Appeals for the Kickapoo Tribe in Kansas, appellate judge at Mashantucket Pequot Nation, Supreme Court judge for the Iowa Tribe of Oklahoma, Attorney General for the Kickapoo Tribe of Oklahoma, and has served as district judge at the Seminole Nation of Oklahoma and as Attorney General of the Sac and Fox Nation. He is admitted to the Oklahoma Bar, U.S. Supreme Court, U.S. Court of Appeals for the 10th Circuit, U.S. District Courts for the Northern, Western, and Eastern Districts of Oklahoma, and numerous tribal courts. While working in association with G. William Rice at Rice and Bigler, the firm argued and won the landmark U.S. Supreme Court case of Oklahoma Tax Commission v. Sac and Fox Nation. He has helped draft and implement numerous tribal codes and litigated in support of tribes in tribal and federal forums, along with occasionally being the focus of cases attacking tribal court jurisdiction. More recently, Judge Bigler has worked on Violence Against Women Act issues with several of the tribes he works with, or for being among those who have implemented the special criminal jurisdiction allowed to be asserted by VAWA. He is Yuchi Indian, enrolled with Muskogee Creek Nation, and an active member of Polecat, Kellyville, Yuchi Ceremonial Swamp Ground, located in the northern part of the Muskogee Creek Nation near Kellyville, Oklahoma. The Yuchi are a language isolate, meaning their language is not known to be related to any other language. The Yuchi still have 3 active ceremonial grounds, Polecat being the mother ground, whose fire came with them during removal from Georgia in the 1830s. Ceremonial activities around stomp dance, green corn ceremonies require his commitment every weekend from April through August or later of each year. He has also been at various times very active in Native language efforts. In the 1990s, Judge Bigler helped found and was past chair of the Oklahoma Native Language Association, along with organizing and past co-chair of the annual Oklahoma Native Languages Youth Conference.
I'll read the bio for Professor Kristen Carpenter now. Professor Carpenter, Counsel Tree Professor of Law and Director of the American Indian Law Program at the University of Colorado Law School. Professor Carpenter also serves on the United Nations Expert Mechanism on the Rights of Indigenous Peoples as its member from North America. Colorado Law, Professor Carpenter teaches and writes in the areas of property, cultural property, American Indian law, human rights, and Indigenous peoples and international law. She has published several books and legal treatises on these topics, and her articles appear in leading law reviews. Professor Carpenter has been awarded the Provost Award for Faculty Achievement and the Outstanding New Faculty Award. She has served as Associate Dean for Faculty Development and Associate Dean for Research. She was a founding member of the Campus-Wide Center for Native American Indigenous Studies at CU Boulder. In 2016, she was the Oneida Indian Nation Visiting Professor of Law at Harvard Law School. Before entering academia, Professor Carpenter clerked on the United States Court of Appeals for the 10th Circuit and was an associate attorney at Hill and Barlow, PC in Boston. She gained experience in Indian law as a clerk for the Mashantucket Pequot Tribal Nation and at the law firms of Fredericks, Heister, White, and Sanoski. Professor Carpenter is an elected member of the American Law Institute and serves on the Federal Bar Association's Indian Law Board section. And with that, I'll hand it back over to Judge Bigler and Professor Carpenter.
Okay, thank you very much, Rebecca and Ainsley. And I think that Professor Carpenter might have had a couple of technical difficulties, and I think she's back on now. Is that correct? Are you there, Professor Carpenter?
Hi, Judge. I'm on the phone, and I'm just trying to get back on the website. I seem to have gotten bounced off.
Okay. Well, I guess we can proceed from here. And as I said, thank you very much. I'm hoping we are not too disorganized. This is the first time that both Professor Carpenter and I have done this webinar. This was a presentation that the two of us made to the NIJIT, National American Indian Court Judges Association meeting back in November, I believe it was. And so we've kind of got this, but things that both of us worked quite a bit on. But I think that we'll go through as best we can and see where we go. I will proceed first, and then we'll have Professor Carpenter on after a little bit. As the announcement had articulated, there's three things that we kind of were thinking about when we move forward on this. What is the nature of the tribal courts that we work with and support? They, of course, adjudicate disputes, that they tend to be the focus of attacks upon our sovereignty, and that they can be a institution for continuing on the nature of the social and cultural continuity of tribes. I guess that the question that often comes up, though, or maybe come up, is why would a tribal court or tribal judge, such as myself, get devoted and pulled into the United Nations Declaration of Rights of Indigenous People? And we will talk about that in a little bit. I think that on that first slide, we see our little tribal court swag that we give out at our annual continuing legal education. But I think that one of the things bears repeating and being clear about, especially for those individuals here who may not be working in Indian country and living within Indian country, state court judges or otherwise, and sometimes we forget ourselves, even those that are working in it, is how nuanced, sophisticated, and complex our tribal societies were and still are. It's also important to remember that and articulate that our societies and institutions are not only that beautiful, but they are also under assault. And it's not necessarily a conscious or purposeful assault. That can be that. But even as the ocean may not be have any animosity to the shoreline, nonetheless it can erode and destroy it. And that's what it is with the tribal courts and our tribal institutions. We'll talk about tribal courts in particular, is that we're simply surrounded by the mainstream society that can wash over us in so many different ways unless we are conscious and working towards its preservation. Now, I wrote an article here that Professor Carpenter had encouraged me to get published just because it was a series of thoughts that I'd put together regarding the Declaration and our traditional societies when I would go out and visit my ceremonial people, the chiefs and others during the summers on the weekends, as to why we should or shouldn't get involved in these international efforts. But it got me to thinking, and this is the title where it comes from, was Shotwane in Yuchi, means rabbit. And there's a story that my mom and some of her older women folk used to tell. We call them the Ile, which are legends. And the stories, whatever you might call it, kid stories. In that, Shotwane is always kind of a rabbit's always kind of a troublemaker and a character, you might call him. But one day, all the animals were concerned because they had gotten a problem problem with goji flat. That's a monster, you might say. Because goji flat, the monster, was eating all the other little animals. And so they gathered together, the animals gathered together to worry about what they were going to do because they couldn't, they were scared about being eaten. And so they all went around about what should be done, but nobody had the courage to do anything about it. But Rabbit was trying to impress some people, so he jumped up and said he'd take care of it. And so they're all excited and congratulating Rabbit for being so brave. And he was all feeling pretty cocky about his efforts and being congratulated. But that next morning, when he was time to go off down that trail to find and to kill this monster, as it had been directed, he got a little nervous about it. But nonetheless, he went down the trail. And so as he's going down that trail through the woods, he came upon Monster. He heard him coming towards him. Goji Flat was coming towards him. And so Shachwana yelled out, "Dikati, Dikati, my friend, my relation." And so Goji Flat saw him, and they stopped and started talking and visiting. And the afternoon went on, and pretty soon it got a little bit late towards evening, and Rabbit said, "Well, it's been a long time since we visited. Maybe we should eat a little something." And they said, "Okay." So they ate their supper, and then it got towards dark, and they had lit up a fire, and so they were talking, and Rabbit told Goji Flat, "Well, why don't we dance a while? And we'll have a dance." And so they agreed to that, and Goji Flat was all excited because he hadn't had a chance to do any stomp dancing in a while. But then Rabbit said, "Well, before we start, I was just kind of curious. You're so big and strong. I was wondering if there's anything that would even harm you." And Goji Flat said, "Well, there's this little bitty bug. You know, I know people get scared of bugs, but, you know, for me, it's just my big toe is where all my power comes from." It said, "As long as I have that, as long as I have my big toe, I'm safe." And Rabbit said, that little bug, that's interesting." And so off they went and started dancing. And first, Goji Flat would lead, and then after a while, Rabbit would lead, and Goji Flat would be answering. And then the next thing you know, Rabbit took out his hatchet, chopped off that big toe of Goji Flat, and Goji Flat was rolling around and making noises. Pretty soon he died. And so Rabbit went back to his people, and they all celebrated and had a big dance afterwards. Now, in one way, that's just a little children's story. You might say that you tell at night to your kids, or that would do it, and families would tell those amongst the children and pass them along. And this was always, of course, done in our own language, Yuchi. And even though it's just a little children's story, in another way, it shows that those animals, that people would gather together in council to discuss common issues, and that decisions would be made by the group up to and including taking care of punishments for transgressions of societal norms, that is, with killing or eating other people. And in Yuchi, of course, when Rabbit sees Monster, he yells out in Yuchi to him that he's, you know, my friend, my relation, my cousin, Gogala, Gogala. And in Yuchi, that carries a lot of meaning and importance when you're calling somebody your relation. And those two words are tied together, of friend, Dikati, and Sitokala, both have a tying together, you might say. And then as they're eating, it shows that you have these important concepts of dances and ceremonies, the stomp dance in the fireplace, and how you're supposed to react and treat each other. So even though it's just a little kid story, you might say, it shows that there was society, there was structure to it, that there was dispute resolution, that there was not all tribal societies were restorative, that in fact some of us believed in retribution and revenge. And so these little nuanced stories can take forward the complete culture to the extent that you're aware of it. So as you lose these things, or if you're able to retain them, you may be able to have a more full society. Now, the Navajo Nation has been very good in their courts about incorporating their traditional concepts into the disputes and into their decisions. They use their language. They have concepts that are articulated and define how each other are to react and the duties owed to each other. Some tribes don't have that as much. But as you can see from our tribal court, we have a fairly modern-looking system. It doesn't differentiate that much from what you might see in the state or counties. But the question is, what can we do to carry forward that which we had previously? And that's a list, if you look at your slide, that's a list, a marker to where this story and article that I'm talking about is contained. So with tribes, we often talk about self-determination. What do we mean? What is it that we want to be in 30, 40, 50 years? And this is internal to the tribe. What do you want to be? What do you want to retain? Government, casinos, healthcare, housing, is it just things? Or does it include society, culture, language, religion, community? And if so, what are you going to do to get there? Now, in 1906, the Creek Nation had the Allotment Act go through, and that what had been a large contiguous landmass here in Indian territory then became Oklahoma on the eastern half. But one of the great leaders of resistance was Chito Hardro, or Crazy Snake. And he made a speech to the Special Senate Investigating Committee back in the 1906 when it came to Indian Territory, Tulsa area, stating that he had always been asking for justice, and that's all he had ever sought, but that he had never received it. And that it was taken away from us after it had all been set out in the plain and the open through these discussions and these treaties. And he was the last armed resistance to this. Very eloquent, talking about how we must keep our ways and land masses and court systems together. But importantly, the traditional people had elected him as their chief, but his eloquence was in part because he was one of the traditional leaders at his ceremonial ground, Hickory Grounds at the time. Now, I'll back up a second. When the Allotment Act went through in 1900 or 1906 here in Oklahoma area, with the Creek Nation, the destruction of the tribal courts was a conscious, purposeful part of a way to force allotment onto the Indian tribes. The Creek Nation, the Cherokees, and some of the other tribes had sophisticated, fully developed tribal courts that they believed in and loved, and they were suppressed consciously through federal legislation in order to force the tribes to accept them. Now, the tribal courts have always been at the tip of the spear of attacks upon tribal sovereignty. If you look at the decisions over the past 40 years, that becomes pretty clear. We have Oliphant versus Suquamish, which said that tribal courts cannot prosecute non-Indians. You have Mississippi Choctaw versus Dollar General, which was just a few years back. That was whether or not Dollar General, which is on the reservation land and involved a sexual abuse of a Dollar General manager of a Mississippi Choctaw youth in the tribal youth program being placed at Dollar General for the summer internship, whether that Dollar General could be hauled into tribal court, and perhaps but for Justice Scalia's passing, we might have lost that case. It ended up being a 4-4 tie. So, but there, the think it was Justice Kennedy had made a statement in oral argument that, I'm sorry, Counselor, I can't get past square one of where the tribe ever gets jurisdiction over non-Indians. So that was sticking out there. And now, today, as we speak, we have the McGirt case here in Oklahoma, which is the Creek Nation Reservation map case. Prior iteration was Murphy, and so but it's now involved Mr. McGirt, and whether the Indian reservation would continue to exist, and then whether or not, of course, tribal courts would have jurisdiction over these matters. So we see that tribal courts are always being attacked in the federal system. Now, in the congressional side, and this is recognized by Congress, recognized and incorporated into Supreme Court precedents, is the plenary power doctrine, which says that the actions of Congress regarding Indian tribes as Indians is a political question and therefore not subject to review by the courts. So that when you have the Allotment Act passed, when you have the reservations broken up, when you have them sold out without the asking of the tribes, when you have the treaties violated by the Congress of the United States, the tribes aren't able to force compliance with those provisions of the treaties because it's a political question and thus subject to the plenary power. We may get monetary compensation, but we can't undo it. The plenary power is so complete that, in fact, that in the 1950s, Indian tribes were terminated. In other words, they were ceased to be recognized by the federal government. And that was not reviewed undone by the courts. Now, that plenary power still continues to exist, and you still have the ability to terminate Indian tribes. So, that has not happened. Many of those tribes have been restored into federal recognition, but not all of them. So if this federal oversight, supervision, knowing are problematic, and if we don't, the question is, if we do not have an inherent right to exist, then how can any of the other foundational issues we might raise be addressed? Because we can't ultimately seek recourse in the U.S. Supreme Court. Congress has plenary power over us, so where do we turn? Well, that's where I started looking around, and other people started pointing to me, saying that in the United Nations, they have now, in the past 10 years, adopted this Declaration of Rights of Indigenous Peoples, which has some 47 different articles, I think, touching on lands, culture, elderly, economic, health, all of the various possible concerns. But Article 3 states that Indigenous people have the right to self-determination. By virtue of that right, they shall freely determine their political status and freely pursue their economic, social, and cultural development. That essentially means that we have an inherent right to exist. Once we establish that or recognize that human right, then we can go forward with these other things that we care about. And this is getting into the Declaration, and now what I know that Professor Carpenter will probably much better suited to this than I. But we have a right to maintain and strengthen our distinct political legal institutions. Now, to me, a tribal court is a legal institution. So that's where I see the tribal courts getting involved in the Declaration and why we care about it. Now, I think Professor Carpenter will talk some about, well, several different things, but she will talk about the different forums, the different bodies within the United Nations that address Indigenous peoples worldwide and in the United States in particular. But they meet, of course, in New York City, annually or semi-annually, and there's also the Human Rights Forum in Geneva, Switzerland. That's a long ways to go for us tribal people. Even New York City, I don't really, Professor Carpenter keeps trying to get me to go to attend these things, and I tell her I just don't get out that much anymore. But they are important. However, it's not merely a matter of us going to the international level and looking at the international scenery and looking and discovering what can be done before a Human Rights Commission of the United Nations or in Geneva or even in New York City. Because these are concepts, human rights concepts, that we ourselves understand as Native people. Article 31 of the Declaration, and here at the Muskogee Nation I have been pushing, and we have translated most of this declaration into the Muskogee language. And it's been a really exciting and fascinating discovery for myself. I'm Yuchi, which are within, Yuchi people are within the Muskogee Nation, but we are not the same people. We have a different language, slightly different history and culture, but outsiders probably wouldn't notice the difference culturally or socially, although our language is completely different. But I'm helping them on this project of translating. Article 31 is that Indigenous people have the right to maintain, control, and protect their cultural heritage, traditional knowledge, and traditional cultural expressions, et cetera, et cetera. Now, the Creek people here, the Muskogee speakers, have in fact translated that word for word or as accurately as they can. But in doing so, we've had the traditional people involved in this, and they said, you know, we understand what that says in English. And this first translation in Muskogee language is pretty literal translation of it. But we understand this article in the way and context that our old people talked at our ceremonial grounds, that our old chiefs and traditional speakers would talk about it. And when Article 31 says we have a right to maintain, control, and protect our cultural heritage, traditional knowledge, and manifestations of our seeds and oral traditions and literatures and so forth, they said, what we are understanding, what our old people would say, now these are our ways that were given to us, and it is very sacred and is not to be played with. And by that they meant that these things were things which were ours, were passed down to us in a certain way, and they should be maintained in a certain way and respected, and only certain people should be utilizing them or be able to share or discuss them or perform them. So that's how they understood it, and that's a very powerful statement. And if you look at that last part of Article 31.1, Omaf, in Muskogee, as I'm told at least, some of these things mean that it is only one way that it should be, and there is no other way to look at it. It shall be, Tawashi. So that's what going through this declaration does. So they understand these concepts in Muskogee. And as we develop them, then we start seeing that they are actually norms and law. So we understand human rights from a Muskogee or Native Indigenous perspective. Now, backing up just a bit, as a tribal judge, let me start that over again. If you're a state court judge and you make a decision and somebody disagrees with it, basically the only way the federal courts are going to look at that is that if it goes up to the state Supreme Court, and then a petition for cert is granted into the U.S. Supreme Court. That's a long, difficult path. It has to go up, straight up, and then whether it is reviewed in the U.S. Supreme Court. But the simple decision of the state court is not itself directly attacked at the federal district court level. The way you get into federal court, at least as I understand it, at the federal district court level is through diversity or federal questions. But those two methods are not directly attacking a state court decision. Unlike tribal courts, where if a tribal court makes a decision, we often or regularly end up in federal court, district court, being attacked on our decision. As you heard, I've worked in a number of different tribal courts, both as a prosecutor or attorney general or as a judge. I've worked with the Kickapoo Tribe of Oklahoma, the Sac-and-Fox Nation. I've worked for the Pawnee Nation. I've worked with the Kickapoo Tribe in Kansas, and now I'm here at the Muskogee Creek Nation. At each one of those stops, I have had a decision or case I've worked on attacked directly by being filed in federal district court. Those are attacks upon our authority and our institutions. That does not happen in state courts. So then the question is, what can we do to protect? That's something that I'm always consciously aware of, that there may be a case that's going to go up and be looked at or reviewed by a federal court. Well, there's a couple things you can do. Of course, you have to make sure that you're meticulous in your reasoning and grant fairness and due process. But if you also have some type of other foundational basis you can tie your decision to, you may be better able to withstand exterior attack. Now, is this based upon your traditions or your values that you may be aware of as a tribal judge, a tribal person? Then you need to articulate them and base them. But having this international human rights perspective, even if you don't cite the Declaration, gives you a structure of which to analyze and form your written opinions and thinking, so that whether you borrow anything from the international perspective, these human rights structures give you a way to shape, at least occasionally, the decision. Now, many of our decisions really aren't that different than the state courts and the family law. Here at Muskogee Creek Nation, we utilize the state law, for state statutes and so forth for our family law decisions. But we still do things as Muskogee people and Muskogee courts. And there are sometimes things that we look at. One of our Supreme Court decisions a while back had a question of whether or not the opposing party would be allowed to present additional evidence or arguments. And they went through that on the due process arguments and looked at our codes. But because we had two traditional chiefs on our Supreme Court at the time, they referred to the fact that this is in line with Muskogee traditional law, where when there was a dispute in the traditional settings, the chiefs, who would be the decision makers, the adjudicators, the mediators, would allow both sides to fully say their piece so that all sides could feel they had a chance to be heard, and that then the decision was made. And that when we have to make a decision as a court of Muskogee people, we will err on the side of elocution. So we see that these things all start tying together, and that although we may have a tribal court, we look at where we will pull our decisions from. And let's see, I think, let me make sure I did not forget something here. So I think that as a tribal court, we want to, and these are some of our traditional chiefs from my ceremonial grounds, two of them plus our traditional speaker at that time. But we want to see where we are able to develop our native institutions. As we're surrounded by exterior sources, the state courts and the federal courts and legislatures, we have to more consciously think about what parts we are going to retain and how we are going to justify them upon attack and how we're going to defend them. Not all instances will they be different from the outside, but if it is something that we believe in, it seems to me we should incorporate our customs and traditions and carry them forward as part of our indigenous legal institutions. So I think I've gone on about 40 minutes all told with the introductions. I don't want to take up all of our time. Let me see if Kristen wants to come over here in a bit. I will say before I hand it over to Professor Carpenter that I have known her since she was in her law school days, and she was a bright and shining star at that time, and she has gone on to other great things at the United Nations and in the law school. She has written a lot of articles. She's been very encouraging in the young people now coming forward, and so we're very hopeful very thankful that she is with us today. Professor Carpenter? You there, I hope?
Yes, thank you, Judge Bigler. And thank you for your excellent presentation. Judge Bigler and I have a lot of mutual admiration for one another, and I mean that in the sincerest way, in that as I work both in Indian country in the United States and with Indigenous peoples around the world, he is really one of the most visionary individuals I've had the chance to work with, and especially around tribal cultures as a basis for contemporary approaches to governance questions that are facing Indigenous peoples. And so I think that his work is really important, and the role of the tribal judge, not only in deciding cases, but in educating the community, is one that he has really taken to heart. Those of you who've been to the Muscogee Creek Nation's annual conference, Doing Business in Indian Country, I think have been able to see that in person. And together with our shared interest in the United Nations and the Declaration on the Rights of Indigenous Peoples, Judge Bigler and I have been trying to take opportunities like this one to share some of our thinking and our work with constituencies who may be interested in doing more work at the intersection of human rights and Indigenous cultures in their own communities and elsewhere. I want to thank NIJA, too, for making this opportunity possible for us. My very first slide is about access to justice, and I think that this opportunity itself, making this conversation available freely to interested lawyers and others is an important point of access. As Judge Bigler mentioned, or maybe Rebecca mentioned, I serve, I'm a law professor normally, and I also serve on a UN body called the Expert Mechanism on the Rights of Indigenous Peoples. This is a picture of the UN in Geneva, and these flags are kind of a famous image representing the 193 countries of the world that are members of the UN. And the UN is the international institution of governance that is devoted to peace and justice. And I think increasingly, although some of this work started with Indigenous peoples going to the League of Nations as early as the late 1800s and early 1900s, but increasingly, I think Indigenous peoples in the United States and elsewhere have asserted that when it comes to the international institution that's devoted to peace and justice, their interests as Indigenous peoples should also be a subject of concern for that institution and its particular bodies that I'll talk about and its instruments, its documents. And so the topic of Indigenous peoples and human rights, as Judge Bigler said, we could think about it in lots of contexts, and we can think about it in tribal communities, in tribal courts, as Judge Bigler has shared. We can think about human rights as they operate in our domestic legal system in the United States. And federal Indian law, as we all know, is very much a matter of domestic law in many regards. And so one of the things that we want to do is to think about how these human rights ideas could fit into that kind of advocacy. And then there's advocacy at the United Nations itself. I'm trying to advance my slides and they're not moving, so I'm just letting the organizers know that.
Patricia, can you advance your slide?
I'll keep talking, but in any event, oh, here we go. Okay, great. So this slide is meant to illustrate some of the ideas I just shared, and that is that international human rights law, and especially the UN Declaration on the Rights of Indigenous Peoples, can be implemented in several different settings. And with my frequent co-author, Angela Riley, who is herself a tribal court justice, she's the Supreme Court Chief Justice at the Citizen Potawatomi Nation. We have done some research too and written an article that is kind of summarized here in this graphic, talking about a jurisgenerative moment in Indigenous rights. And Judge Bigler and others have teased us for using such, seemingly formal terms. But this idea is just that the current moment in law is a law-creating moment, one where things are changing, and where Indigenous peoples in particular are asserting their own needs and interests and values in many different settings, and especially in these three settings, in Indigenous or tribal law, advocacy, in national law, and international law. So one of the things that I'd like to talk about a little bit is how this UN Declaration on the Rights of Indigenous Peoples, first of all, what it says, and Judge Bigler already started that conversation, but also how it can be implemented. Because it's one thing to have this declaration, which itself is a big achievement. And for several generations, before I was a lawyer and when I was a law student, many of the leading Indigenous advocates were making the case at the UN for this document. And as Judge Bigler said, it's 46 articles that articulate the fundamental rights of Indigenous peoples as individuals and as collectives as a matter of human rights law. Rebecca posted...
Professor Carpenter, if I might,
sure.
Just a moment.
Yep.
I think it's important for people to understand that this declaration was also very much started and initiated by Indigenous traditional people. That one of the reasons that the Muskogee Nation is so supportive of translating the declaration into Muskogee language was that one of our traditional Indian doctors or medicine men back in the 1978 went to Geneva and led the way into the Human Rights Organization at that time to foment for this. That was Philip Deere. So that's just so there's a little background on that.
Well, I'm glad you mentioned that because I really feel from that history and from many others who are involved that the Declaration really is an Indigenous document. And what I mean by that is that it wasn't a bunch of European state leaders at the United States who got together and decided what Indigenous rights should be, but it was Indigenous peoples themselves going to these meetings and discussing amongst themselves and bringing their own tribal values from throughout the United States, but Canada and Africa and Russia and Asia and South America. And they spent, 25 years negotiating among themselves and then with states this declaration. And my own feeling, having spent a lot of time with this declaration and talking to people who were involved, is that it truly does reflect Indigenous values. And that gives it a lot of potential, and in some ways potential that other international human rights documents don't have, because it specifically speaks to the context that Indigenous peoples are living in. And so you might contrast it with some other also important documents like the International Covenant on Civil and Political Rights or the Covenant to End Racial Discrimination. And those two apply to Indigenous peoples, but they don't speak directly to their circumstances. So a very helpful thing about this declaration is that when, for example, it's talking about land rights, it talks about them not only as property, but in terms of Indigenous peoples' spiritual relationships with lands. And when it talks about traditional knowledge, it talks about Indigenous peoples' own laws, customs, and traditions as a source for that knowledge. I was starting to say that Rebecca posted on the chat for everybody a link to the declaration itself. So for those who are listening and may want to look at it, I recommend that site to you. When I give presentations in person, I always hand out the declaration, and I encourage everybody to carry it with them. I literally carry it with me all the time in my purse, and I often find that there are moments of advocacy where the declaration is particularly suited to inspire progressive thinking about Indigenous peoples' human rights, or possibly legal reform when it comes to some of the things that Judge Bigler talked about. You know, how do we address problems like plenary power or the lack of religious freedom for Indigenous peoples in the United States? And so I encourage people to become familiar with this instrument and to click on the link, or you can order a copy if you want a paper copy as well. I'm going to try to advance my slide here so we can. Great. Okay. So we're in the midst of a worldwide movement to implement the Declaration on the Rights of Indigenous Peoples, to make those principles that are stated in the Declaration real in the lives of Indigenous peoples. And I was starting to say that the Declaration itself is an accomplishment, but it'll only really make a difference if it can apply to the real-life circumstances of American Indian people and other Indigenous peoples around the world. And Judge Bigler, I think, very powerfully pointed out that you don't need to go to New York and you don't need to go to Geneva to do this work. And the Declaration on the Rights of Indigenous Peoples can apply in tribal justice systems, can apply in all of the branches of U.S. federal mechanisms at the UN in case people are interested in them, and also just so that they have increased awareness of what's happening in those bodies. As I've been serving on the expert mechanism, and I'm now its chair, my whole term will be 4 years, it's been a little disappointing to me, to be frank, that there aren't as many American Indian tribal leaders attending some of the UN forums as I would like to see. And of course, I understand the problems of cost and time that are major hurdles, but I really would like to see more American Indian tribal leaders in those to be heard directly, although there are other ways to influence what they're doing, and I'll talk about that in a moment. But just quickly, there are 3 Indigenous peoples mechanisms at the UN, and that just means 3 sub-institutions that are dedicated to Indigenous peoples' rights. And the 3 of them are shown here on the slide. So the Special Rapporteur on the Rights of Indigenous Peoples is a single person by the Human Rights Council every 3 or 6 years, if she gets 2 terms, to investigate human rights violations on the ground that may be affecting Indigenous peoples. And so, for example, when the protests were happening at Standing Rock, the UN Special Rapporteur on the Rights of Indigenous Peoples went to Standing Rock to assess what was happening on the ground vis-a-vis various human rights instruments in terms of potential violations of collective rights to land, consultation, resources, and individual rights to expression, to liberty, to be free from violence, and so on. The Special Rapporteur right now is Vicky Tauli Corpuz. She's an Indigenous woman from the Philippines. And she has spent the last 6 years traveling the world, bringing attention to violations of Indigenous peoples' human rights on every continent, as well as completing thematic reports, most recently on Indigenous peoples and governance. And Judge Bigler has mentioned that as an interesting study for tribal court judges and others to look at, tribal leaders, because of its focus on governance. In the middle icon is the UN Permanent Forum on Indigenous Issues, and this is a sub-entity of the Economic and Social Council of the UN, and its role is to provide advice on economic and social issues affecting Indigenous people. And of the three mechanisms, this one might be the best known in the United States because it meets in New York, whereas the other two, their home bases are in Geneva. And every April, the Permanent Forum holds a major session, and Indigenous peoples are welcome to attend. They can attend the forum in their own capacity. They don't have to go under the rubric of a state government or an NGO. They can register, and actually the registration is open right now. And that's a 2-week period where Indigenous peoples can speak to a whole host of issues affecting them. And the Permanent Forum listens to those issues and then makes recommendations to the Economic and Social Council. And the Economic and Social Council is comprised of state governments, which is just national governments, let's say France and the United States and Germany and Brazil and so on, about measures that they should undertake to protect Indigenous peoples within their territory. And then finally, yes.
I'm sorry to interject. I just wanted to remind the participants that the chat room is for everyone. If you have questions within this presentation for Professor Carpenter, or even for Judge Bigler, please utilize the chat feature to the right. It's not just for us, it's for you all to introduce yourselves or to ask questions. And thank you. Sorry about that. I just wanted to remind everybody, Professor Carpenter.
No, I appreciate that, Rebecca, especially because when I'm teaching, my students always jump in with questions and comments, and so just doing a monologue is not as satisfying as interacting with people. So I do welcome questions and comments. Just to complete this thought, this final body is the expert mechanism on the rights of Indigenous peoples, and that's the one that I serve on. And ours is a subsidiary entity of the Human Rights Council, and we advise the council, which is also comprised of national governments, on human rights issues as they affect Indigenous peoples. So the council looks at everything, let's say, from migration to civil rights to women's issues, poverty, social justice, human rights defenders across the entire world. But the council itself doesn't have special expertise on Indigenous people. So there are 7 of us appointed from each of the worldwide regions to say and advise the council on how those general issues play out in the Indigenous peoples context. And we do that also through an annual session. We have seminars around the world. We try to meet with and hear from and share the concerns of Indigenous peoples, and also provide opportunities for them to share those concerns directly. I'm going to not belabor these slides in too much detail, and of course you can look at them with greater attention later. But the expert mechanism, even more specifically than I mentioned a moment ago, our mandate is to help states and Indigenous peoples implement the Declaration on the Rights of Indigenous Peoples. And so we have an obligation to receive requests regarding things that they would like to change in the national laws of their countries, especially to better people. And I think I have several examples of some of the ways that tribes, and as Judge Bigler said, some of these do, but some of them don't require traveling. And so I'll just run through them quickly. And this is a picture of Terry Henry from the Eastern Band of Cherokees and some other folks that people may know giving testimony before an international body on issues of violence against women. And that was an area where tribal leaders really used international forums in a very effective way to support the worldwide movement and its iteration here in the United States on Indigenous women's rights. But some of the things that tribes can do if they're interested in engaging with this body of international human rights law and figuring out how the Declaration might be useful in their communities, number one, they can request that the expert mechanism come to their community, and that can occur formally through a country engagement. And so we currently have one from the Yaqui people in Arizona, and we have others from Indigenous peoples around the world, but that's the one that we have from the United States right now, where the Yaqui people have asked the expert mechanism to help them with an international repatriation question. Two, tribes can participate in our studies. And we do studies, as I was saying, on a whole bunch of different topics. This year's topic will be land rights. And we have seminars, and we try to invite at least one Indigenous person or somebody who's otherwise expertise on Indigenous issues to come from each of the regions and share information. This year, Stacy Leeds from University of Arkansas and Cherokee Nation, who may be on the call, attended our land study. Last year, Fawn Sharp, now the president of NCAI, attended our study on free, prior, and informed consent. So we've had some really excellent contributions along those lines. Third, and sort of less formally, tribes can invite MRIP not for formal country engagement, but just for a visit. And Judge Bigler, along with a number of the ceremonial people in Oklahoma, invited me for a visit when I was newly appointed, and we had the chance to just talk about human rights issues and some of these points. Fourth, as I said, you can attend the permanent forum in New York City or even attend the MRIP session in Geneva. Those are in April and in June, respectively. And yes, I know they're very far and very expensive, and it might be a careful selection about whether it makes sense for tribal leaders and others to use resources. But it is an excellent opportunity to assert tribal perspectives on human rights and have a chance to influence these resolutions that national governments are going to be encouraged to pay attention to. And so, for example, last year we had a resolution coming out of the Human Rights Council with respect to the rights of Indigenous peoples as migrants. And that's a resolution that the United States and all of the other 193 countries are encouraged to put into place, to pay attention to. And so if there are things that you really, from your community, whether you're a judge or a lawyer or a member, that you would like to bring attention to, attending one of these sessions is perhaps a worthwhile thing to do. And then fifth, and this is the easiest thing, there's a mailing list of DOSIP, which is an Indigenous Peoples Support Group at the UN, and just subscribing to this, and I have the link here, can keep you up to date with all of the Indigenous matters happening in the UN. And you'll get these emails every week in your inbox, and then and you can kind of just, couch surf and pay it and keep up to date about it all, and then decide whether you and your tribe and others may want to participate in any of these kinds of things. I'm going to pause for a second. Judge Eichler, were you going to chime in? Yeah.
Yeah, one of the things that I would really point out is that when we brought in Professor Carpenter to speak with our traditional ceremonial people here maybe 2 years ago, a year and a half ago, that was really worthwhile for me and for our people, because it started having our community, traditional people, understand and think in terms of these human rights documents and principles. and that that creates a dialogue that we start educating ourselves about these human rights norms or Declaration of Rights of Indigenous Peoples, and we start utilizing them as we start educating ourselves. And becoming educated is extremely important within our communities. For instance, one thing that we probably some of them wouldn't have thought of as I just am like a broken record over, or I'm not sure anybody knows what a record anymore, but I keep repeating nonstop. Let's say it that way. But for the Declaration of Rights, and as a tribal court, we've talked about being able to utilize our own institutions. And one example of this that we might think about is in the Violence Against Women Act, where we are making such strong efforts to protect primarily our women, but all others who might be subjects to violence in dating relationships and so forth. But one of the things that we worry about is that in the 2013 Violence Against Women reauthorization that's before Congress right now, or was before Congress, there were a couple of versions put forward that were very, that really were attempting to destroy the way that we did things, that they had to follow precisely what was being done in the state courts and federal courts, so that if we tried to utilize those institutions and norms that made us strongest, we couldn't incorporate the special domestic criminal jurisdiction. And that was a provision which allowed us to prosecute non-Indian violators. And so that we had to make the choice, do we give up our traditions and customs which keep our communities whole and healthy, or do we adopt these provisions which simply adopt state law or federal law provisions? And it seems that that is a question of whether or not we are allowed to retain our indigenous native institutions. So that's one instance of how we can think about these things. So back to you, Kristen.
Professor
Thank
Carpenter,
you.
I wanted to
Yes.
I wanted to interject really quickly. We have a question from Robert Wakefield. He asked, what authority does the UN have to make an individual member country comply with its decisions? And then we have a poll when you're ready.
Okay, that's great. And while Judge Stigler was speaking, I scrolled through the slides and found that visit to Kellyville, where, as you can see, I'm the very shortest person and only woman, with a group of very distinguished Stomp-Down leaders from 3 or 4 tribes. And we really did have a great visit, as Judge Wiggler said, and exchange of information. And other tribes are absolutely welcome, as I said, either formally or informally, to invite the expert mechanism or other bodies of the UN to visit them in their communities. But to go to the question, and Mr. Wakefield, that's a terrific question, and it's one that I've thought a lot about. It was interesting to go from being a lawyer trained in the United States, where typically when I've represented tribes, it's been in litigation largely, and what we're looking for is a judicial decision, and we know how that is enforced as a matter of U.S. constitutional law, procedure, and practice. But in the UN, it's certainly different when it comes to compliance and enforcement. And instead of legal judgments, the process is one of diplomacy. And the 193 member states of the UN have agreed to be bound by entering into the UN Charter to these fundamental principles of peace and justice and individual rights and so on. And that's kind of the baseline for the entire UN process. And all of these sub-bodies, the Human Rights Council, the Economic and Social Council, and so on, they're comprised of those very same states, those 193 states. And what they do is discuss and negotiate among themselves how they're going to live up to the principles of the UN Charter, and then also things like the Universal Declaration of Human Rights and the treaties that put those into place. And so largely there is no way to make an individual member country comply with the UN's decisions, but to persuade them or to induce them or to encourage them. And that has to do with finding shared interests. And some of those shared interests are well known. They have to do with economic well-being and security around the world. When it comes to Indigenous peoples' rights, I think especially because Indigenous peoples are relatively small in number around the world, and they've been so vulnerable and so disenfranchised, making the case for honoring Indigenous peoples' rights sometimes takes a bigger lift in terms of diplomacy. One of the things that I think we've done over the years is to find member states that are sympathetic to Indigenous peoples' issues, at least relatively sympathetic, and encourage them to lean on one another, to listen to these Indigenous mechanisms, and then to be informed about what would be helpful and important and just, and then to put those measures into place. I could say a lot more about this, about diplomatic processes as they impact Indigenous peoples, and specifically about implementation of the Declaration. I guess before I leave this topic, though, I'll say, given this international movement to implement the Declaration, a lot of us are thinking about how to do that in the United States. And Judge Bigler just posted, we have a joint project of the Native American Rights Fund and University of Colorado, where I'm on the faculty, to implement the Declaration. And some of the ways to do that include Congress could pass law, deciding to ratify the Declaration as a matter of federal statutory law. Administrative agencies can decide to adopt the Declaration in whole or in part as aspects of their own internal policy. The Advisory Council on Historic Preservation has already done that with respect to the Declaration and sacred sites. And courts can also decide to cite to the Declaration. And when they do so, it gives the Declaration more and more power and more force as a matter of law. There is one federal court so far in an American Indian case that has cited the Declaration, and that's the District Court in New Mexico in a case involving Jemez Pueblo about Aboriginal title, citing some of the land rights articles of the Declaration. All of those actions are steps towards making the Declaration a part of U.S. law. And as the U.S. incorporates the Declaration increasingly into its own law, the U.S. will itself be deciding to be bound by this set of UN standards. I know I'm really sounding like a law professor here, going on and on, but I'd be glad to take any follow-up questions on that topic. I did also want to respond. I see that I think it's Angel Smith has mentioned that we have an upcoming study on children's rights, Indigenous children's rights, and I'm going to scroll a little bit back through the slides. We will be devoting the 2021 study to the rights of Indigenous children, and that was in part inspired by things happening in the United States and the challenges to the Indian Child Welfare Act, and perhaps unsurprisingly, there are similar challenges to legislation in Canada and Australia and New Zealand, other settler states, and then other countries around the world where they don't even have such legislation to start with. And so for all of those reasons, we were inspired to look at the study on the rights of Indigenous children. And this is an area where we would love to get submissions from ICWA attorneys, from tribal court judges, about, how can the United States do a better job of protecting the human rights of Indigenous children. And I think the word child appears in the Declaration at least 9 times, maybe even more. And so to the extent that Indigenous children's rights in the United States could be described in terms of some of these articles, it helps to make the connection to human rights. But you can also just, talk about local circumstances, and that's also very helpful to us as well.
Professor Carpenter?
Yes.
Would you like to do the poll now?
I would love to do the poll. Will you start it?
Yes, ma'am.
Okay. So the question is, have you read or reviewed the UN Declaration on the Rights of Indigenous Peoples? So hopefully everybody's voting. I'm going to vote. Okay, so far it's 100% no. The yeses are making a comeback.
And I think
Okay.
this is Judge Bigler again, and I think that this joint project that Native American Rights Fund, and which is the preeminent nonprofit legal advocacy group for Native Americans in the United States, joint project with Colorado Law School is extraordinarily important. We think it's going to be a long-term project, but we figure hopefully tribes will be here for a while. But as we said, there are just inherent structural problems with federal Indian law and the ability of tribes to determine their own structures, institutions, and legal decisions. So we know something has to change, and as Walter Echohawk wrote in one of his books, I think the 10 worst cases of federal Indian law, there is a way to change that, and that may be a long time. But this declaration, as I said, can be a moral force for change. And it's something that we can use internally at the tribal level. It's something we should push and advocate at the state level, and it's something we can push at the international and federal level. So there's plenty of opportunities, but it is so important that first we become aware of it and educate our communities in it. Because if our communities aren't aware of it, they're not going to want to follow and push it themselves.
Well, that's exactly right, Judge Bigler, and I think given that I am a law professor, I'm going to give everybody an assignment after this webinar, which is to read the Declaration. And we provided the link, and you can also order paper copies for $1 a copy from Kairos, which is an Indigenous organization in Canada. And John Echohawk has said from time to time, and part of the reason why we're doing this joint project is that everything we want is in the Declaration. And I'm always struck when he says that, because he's somebody who has tremendous experience in advocating for the rights of tribes in the United States. And there are lots of criticisms you could make of the Declaration. But from his perspective, and I share this, the Declaration really does powerfully speak to many of the concerns, immediate and long-term, that I hear from tribal leaders and members and lawyers in the United States. It speaks so clearly to the right of self-determination, to individual and collective rights, and it speaks really clearly to some of the problems, the most fundamental problems of federal Indian law, including, for example, that Aboriginal title is not protected as property. The Declaration provides that Indigenous peoples' own land tenure gives rise to cognizable land rights. When it comes to religious freedoms, we know that the First Amendment has been interpreted not to protect American Indian rights to sacred sites on the public lands. The Declaration has several articles which provide that Indigenous peoples have a right to their religion, have a right to protect the lands that they have a spiritual relationship with, and so on. And many of the practical issues that tribes are dealing with on a day-to-day basis, economic development, access to capital, freedoms for members who are trying to participate in cultural events, all of these are addressed in ways that, at least from my perspective, federal Indian law seems more stilted and more colonial in perspective. And the Declaration really is infused with principles that, if we could bring them to apply to the big cases and the day-to-day existence in Indian country, could really make a huge difference. And so, as Judge Bigler was saying, this project to implement the Declaration, and we're about to launch the website, so we'll hopefully follow up from this event and share that with you. We're going to be providing lots of information on it. One of the things will be an implementation toolkit that is directed towards tribal governance systems. So any branch of tribal government, whether it's the tribal council or the tribal court or the tribal executive, could use the Declaration toolkit to think about, how the Declaration could apply in their community. And then there will also be information about accessing some of these international venues to make the case for American Indian rights. So it will be meant to span all of this. Yes, Judge.
One of the things that I had mentioned I was going towards what I forgot to mention on the Violence Against Women Act, for instance, and our tie-in to the Declaration of Rights of Indigenous Peoples with its mandate that we be allowed to have our Indigenous institutions. In order for the tribes to, and there's only about 15 or 16 tribes nationwide that have done this, to incorporate or adopt the special domestic criminal jurisdiction, allowing us to prosecute non-Indians in our tribal courts for violence against women or domestic abuse in our tribal jurisdictions, is that the judges have to be law-trained and bar-admitted. But that, so that means that if we want to have traditional practitioners like we had on our Supreme Court, who in fact said that our traditional due process requires more ability to be heard than in the state, they would be excluded. And so that in order to be recognized in the federal systems and in the federal congressional acts, we have to look more and more like the federal or westernized systems instead of utilizing our indigenous institutions. That declaration would say, no, you may continue on as you see fit that way. And that's a very important point that seems like a small thing, but they all add up. And so that's why we have to look to some place that recognizes this right, because we're not finding it in the federal law, we're not finding it in the congressional laws. And at this point, it's simply trying to have a moral persuasion, but we'd like to see it implemented into a mandatory type law, but that is a long-term project, but we certainly are hopeful.
Thank you. And as we're winding up, I think we maybe have 10 minutes, and I'm open to more questions. I had skipped over some of the slides in the interest of time, but I did want to put this one up for a moment. What can tribal courts do? Because, of course, this is NIJA. And mention that when it comes to implementation of the Declaration, if tribal court judges and others find it salient, there are some immediate things they can do. One of them is to cite the Declaration in judicial opinions. And there are, as I mentioned, there's one federal district court case that cites the Declaration. And you'll often hear that the Declaration is not binding law. And that deserves a little bit of unpacking. In the United States, very little international law is binding unless it has been put through a process of congressional ratification, having been turned into a statute. But that doesn't mean it's not important. The United States did express its support for the Declaration in 2011. 148 countries have cited their support for the Declaration, and in other countries, Canada, Belize, others, courts are increasingly citing the Declaration. And it's available as a source. It's not binding law in the way of a federal statute, but it is nonetheless available as information that you could use, whether it's interpreting an ambiguous statute or as a policy matter, or perhaps as reflects tribal law, because some tribes have, of course, adopted the Declaration themselves. I put up there a couple of tribal courts have cited other pieces of human rights law to inform their own jurisprudence. And this Eastern Band of Cherokees case and the Wallapai case have to do with criminal law and children's rights, respectively, and have really nuanced discussions of how international human rights could help to inform their own jurisprudence and how they relate to tribal law. And I commend both of those to you. And then finally, this comes back to my admiration for Judge Bigler, but I think the role of tribal courts as educators in the community is a very important one. And the Muskogee Creek District Court, through its conferences and through some of the materials that Judge Bigler has now posted on the chat, has a lot of information about how international human rights law could be used in tribal court settings. And I think other tribal courts are also taking on that role. The courts of the Navajo Nation, for example, and others around the country really have some excellent jurisprudence that we can look to as models, and excellent events that we can also attend to increase all of our learning. I think with that, I could go on and say so much more, but I did want to invite any additional questions from our online audience, so that perhaps Judge Bigler and I could take a moment to address those, and maybe while we're waiting for those, Judge Bigler, would you like to add any additional thoughts?
I'm not sure I have much else to add. Like I said, that I know this is kind of a new area for so many people. And it really, as far as implementing the Declaration into federal law, is a long-term project. I think we've made some suggestions as to how and why it's important even at the tribal court level. And it is a long-term process, but the example I use is that back when, before I became a lawyer, my partner, who is now no longer with us, and a couple others here in Oklahoma back in the mid-'70s, early '70s, were going around speaking about, at that time, how tribes had the right to their own courts, that they had a right to, that they had Indian country, they had a right to jurisdiction, and nobody believed them in Oklahoma at that time because there weren't, and nobody believed that there was Indian country in Oklahoma, and there were no tribal courts in Oklahoma. And those two, Browning Pipeston and Bill Rice, thought that was going to be a project that was going to take 30 or 40 years. And lo and behold, State versus Little Chief came out, and all of a sudden there were tribal courts, and there was Indian country. And 40 years goes by awfully quick. The older I get, the faster it goes. So this may be a long-term project, but it will take a commitment from all of us, from the tribal courts up, and our friends in the state courts, and the state institutions, and at the national level, and the local levels. But I'm so happy that anybody was here listening in so that there might be questions and awareness as we go forward. I think that ultimately this is what we see as the new era for Indian rights here in the United States and hopefully elsewhere. Got any questions? Anybody have something?
Well, I will conclude then with, I did want to show one more slide. One of the most powerful things for me about being involved with the UN work is meeting Indigenous peoples from around the world. And what has surprised me, I guess, is how much people really have in common, despite really different circumstances. And so I wasn't expecting that, for example, Indigenous peoples in Russia would similarly be dealing with questions of language revitalization, or what does it mean to enjoy fishing rights when we're talking about, a commercial economic circumstance, or that Indigenous peoples in Australia would be facing such incredibly similar issues with respect to child welfare, or that land rights in Belize, when it comes to sustainability, would really mirror some of the concerns that tribes in the Southwest are trying to figure out as they move from extractive industries to more sustainable industries. And so, again, I know questions of time and resources make this difficult, but I just wanted to share a little bit of a glimpse of the opportunities to get to know Indigenous peoples and their advocates from around the world through some of these forums, or even to, interact with folks through social media and otherwise, and just how powerful I have found it to be to watch and listen when Indigenous peoples get together and share their concerns and advocate collectively on a worldwide basis. It's a really, really powerful thing, and I think it bodes well for them and really, hopefully, for the globe itself. And Judge Bigler, I'll let you finish up.
Thank you. And this is something that doesn't, I guess that as a tribal court, I'm concerned about our community and continuity of our existence. And here, a month or two back, I had fortunate enough to speak to some law students with a couple others who were also other tribal leaders who were interested in seeing this declaration pushed forward into the tribal community. And one of them is a Miko, or traditional chief for Halabi grounds. And he was talking about how at the end of the dance season, the traditional season, he was at one of the other grounds, ceremonial grounds. And he was saying that his point was that tribal people have become so inundated with this, we don't even realize we're being harmed anymore. And what he's referring to was that at our ceremonial grounds, we dance at the night. These grounds, our ceremonial grounds, dances used to be far away from the communities and other cities and towns out in the country. And at night, and the traditional ceremonial fireplace, which we consider sacred, is supposed to be the only light that lights up that stomp ground, and that then you can hear the singing of the men and the women and listen to that. And that's what is supposed to light the grounds, that ceremonial fireplace. And these were fireplaces, embers and sparks that we literally brought with us from Georgia and Alabama 175 years ago, and they continued on into this very date. That very same fire has continued for this period of time. Well, he said at this one grounds he went to, there was a fracking unit, oil rig fracking, injecting wastewater into the ground next to it. Say the stomp grounds is 10 or 15 acres, and this drilling rig, which is oftentimes 5 or 10 stories tall, is lit up with diesel generators and is making so much noise you can't hear the singing, and that it is floodlighting the grounds. And that was right next to the stomp ground. And he said people were complaining about it, but nobody thought a thing about it. And he said, would they have done this to a Baptist or Methodist church to put this drilling rig right next to them, knowing that it would be able to destroy their ability to hold Sunday services? Or do you think that the Corporation Commission of Oklahoma would have injected itself into the proceedings and saying, no, you have to accommodate that church? And yet that never happens with the ceremonial grounds. And so the question is, why not? Why is it not that our sacred places are not protected? How can we do to change that? And so this is the type of thing that we're talking about throughout our communities. Now that's just one small place within Muskogee territory, but those types of little things in different forms happen throughout our Indian country of the United States and North America, and in different institutions, whether it's sacred sites or courtrooms or whatever it happens to be. So we hope that you take something away from this, that you'll learn a little bit more and look into it and keep it in mind as we move forward. So that's really all I had. Anything else? I'm open to discussion or questions, or you can certainly look at these website and links, and we are very happy that you tuned in for this little 90 minutes discussion. Anything else? Conclusion from our presenters or hosts?
Absolutely. I just want to say thank you so much for your preparation, your time, and spending your afternoon with us, both to our presenters and to the folks who tuned in. It was very interesting and absolutely informative presentations. But before we conclude, I'd be remiss if I did not take a moment to talk about NYJA and our work in tribal communities. For those of you that are new to our webinars, NYJA is a national association comprised of tribal and state justice system personnel and others, including judges, peacemakers, court administrators, court clerks, Indian law practitioners, and scholars who are devoted to supporting and strengthening tribal justice systems through education, information sharing, and advocacy. So with that being said, we do a broad range of work for tribal communities, including training and technical assistance to support tribal courts. We are also the main TA provider for the Bureau of Justice Assistance, CTAS, Purpose Area 3 grantees.
Part of our support for tribal courts is our annual conference that's coming up on October 20th through 23rd. It's going to be in Green Bay, Wisconsin this year at the Radisson Hotel and Conference Center. This year we will feature topics that highlight ways in which tribes utilize their courts to strengthen, restore, and protect their communities, and we'll continue to offer cutting-edge training for judges and court clerks. And again, those dates are October 20th through 23rd, 2020. If anyone has any questions or requests, we can be reached at rebecca@nyja.org or ansley@nyja.org. And we can type those in too. Thank you to our presenters once again and for your presentation, and to NCJ FCJ for hosting, and thanks to everyone for joining us today. And that concludes our webinar.
Thank you.